Brian Cortland.
So we're here on the one matter that did appear on the calendar for the court this morning, which is a scheduling conference in a new case, which looks very similar to the older case, except that there are different requests that are the subject of this case. Is that a fair Cliff Notes version of what we have here, Mr. Thomas?
Yes, Your Honor.
I'm curious as to what the parties believe the most appropriate way is to manage this piece of litigation, given that the other case is still ongoing, or whether or not we don't need to do anything special with this, and we should just allow this to proceed in the normal course. And Mr. Thomas, it's your case, so I'll hear from you first in that regard.
Plaintiff wanted to present to this court a plan of filing a motion for collateral estoppel in order to just bar this court from hearing the arguments again and not relitigating the case a second time and then going straight to the penalty phase.
And I'll indicate that I didn't read the answer in its entirety because it was lengthy and I had other matters I needed to attend to, but I reviewed it with sufficient familiarity for today's purpose. It sounds like this issue that was dispositive in the first case isn't the only factual question here, such that there are claims from Lewis County that they did respond in certain ways, and so there isn't just this, we didn't give you anything because it's a judicial agency. There are other factual questions here that might be necessary to be resolved before determining whether or not there's liability. Is that consistent with your understanding?
Plaintiff doesn't agree that there are other factual issues because it's our understanding that Lewis County or defendants are arguing that the court provided documents. So it goes to the same issue that this court ruled on before, whether the Law Library Board is subject to the Public Records Act. The judiciary is not an agency subject to the Public Records Act, and it would be an act of futility to this court in order to rule on records that were provided by the court to Mr. Cortland when a public records officer or the county didn't even respond, like in the first case.
And so the argument on behalf of your client would be that collateral estoppel should be established, and also that while you may have received some documents, they weren't from Lewis County, they were from the Superior Court, and so Lewis County failed to respond adequately. Would that be?
Yes, Your Honor.
And I can anticipate what Mr. Carter's response would be, which is that the idea underlying the first case was that those records were residing with the Superior Court, and so it was appropriate for the plaintiff or the requester to get those documents from where they were then residing. And so we should be having some sort of factual determination about the appropriateness of that before we went to penalties. Is that correct?
Yes, Your Honor.
I'm going to determine at this outset that at the very least, given that there is a dispute as to that we will need to have some determination regarding a violation or liability before we move on to penalty or damages in this case. I would prefer that the parties confer regarding a schedule for a violation briefing and stage. That might make sense to push it out sufficiently far so that there may be a preliminary determination via a motion for summary judgment on the issue of collateral estoppel, just so we don't have a lot of repeated briefing. I'll indicate that I'm somewhat intimately familiar with the concept of collateral estoppel, my understanding being that unless and until my last ruling is reversed on appeal, that is binding. But again, that sounds like that's only a portion of what we are looking at here. And things can happen in the interim with respect to my first ruling. And so my preference would be that we set this for a violation merits hearing at some pushed out time that allows Mr. Thomas time to file a legal motion regarding collateral estoppel in the interim, and we would go from there. Do the parties have any thoughts about that idea?
Your Honor, generally I do agree with that. Obviously, we need to have that determination made And there is also another case that involves Cortland and Lewis County and the same issue that you decided in front of Judge Dixon, in which we anticipate a ruling any day. So I don't know how that affects collateral estoppel as well. I don't know how he's going to rule. But Your Honor, with respect to this case is different. Obviously, as I said in the answer, and tried to make it abundantly clear, the court did provide the records in response in a timely manner to Mr. Cortland. The argument here is that although those records were provided in response to the request, they weren't provided with the magic words, quote, pursuant to the PRA, unquote, allegedly, and that is somehow input. That'll be something that we do need to litigate with respect to this case. The concern that I have is that, as you know, from the existing case that we've had, there's been a lot of motion practice that's been totally unnecessary in this case, the last case. And again, we have one scheduled for next week, or as I understand, next week, a motion to strike the defenses that I raised with respect to defenses that were raised in the prior case.
In this case, next week?
Yeah.
Because I'm not here next week, just want to toss that out there.
Okay, but Your Honor, the problem that I have is that there's a great deal of motion practice, like a motion to strike, that is filed by Mr. Thomas in every case that we've had, which is just unnecessary. And I would like to have some control with respect to the briefing, that we don't do things like that that are unnecessary. We have issues here that need to be decided. One of them is collateral estoppel. Absolutely, we need to decide that. We also need to decide with respect to whether you need to say, when you produce records, that they're, quote, pursuant to the PRA, unquote. Another issue we need to decide. But these are the issues that need to be decided in this case are really pretty limited. And we don't need to be back here every Friday to talk about the third motion to compel something and to go after that. That is just churning the file.
What authority do I have to, and again, if I were to agree with you, which I'm not saying I do, what authority would I have to alter that other than recognizing the fact that parties are entitled to bring motions under the civil rules they have the authority to bring unless it violates Rule 11?
Your Honor, I express frustration. You may not be able to do anything.
Understood.
I understand.
Just wanted to make sure I wasn't missing something.
Yeah, and in terms of the schedule, you know, I don't think that those issues, the motion for collateral estoppel is really kind of like a motion for summary judgment. We can do that pretty quickly, and I would think that we could get to the merits pretty quickly. I would hope that we could get to a merits hearing maybe in December, early January, hopefully at the latest, and just move this along so that someday you don't have to see us all the time.
So that timing sounds roughly consistent with what I was thinking. A collateral estoppel motion, which I understand in a different case has already been briefed in a different context, understandably, but such that the parties here would be somewhat familiar at this point with those issues, and hopefully it won't take that long to brief. So I would like for the parties to confer regarding an order setting up a briefing schedule and a date for the merits hearing. We don't need to put in an order anything about collateral estoppel. Mr. Thomas can file that motion as he can file any appropriate motion. And hopefully that will be resolved with sufficient time before the briefing starts on the merits hearing, that there will be clarity in that regarding that issue. Is there anything else we need to address? I mean, we have a whole list for PRA scheduling conferences. These parties here are very familiar with what we do in PRA cases at this point, so I'm not going to run through the whole thing. The important point is the briefing in the merits hearing. So anything else we need to address?
There is one issue in this present case, Your Honor, the newest case that's in front of you. Plaintiff would like to bring a motion to strike, and this was my fault, where I scheduled it next week, where this court is not in session. Mr. Carter is going to be gone, I believe, from September 8th through the 18th.
Yes.
Is that correct? And then I'm going to be gone the following Friday. And so we would just like a just speedy resolution in accordance with CR1 on this matter. We do believe that the motion to strike is worthy.
What's the gist of the motion to strike?
We are striking two parts of the immaterial parts of the answer, where one, there are material facts that are misstated. So we said that they're immaterial to the defense, and it's just polluting the record. And we wanted to file a motion to strike, and it's also a motion for CR 11 sanctions for misstating fact and law.
So I'm not going to speak to the merits of that motion. As I indicated, parties can bring any motion that is appropriate under CR 11 and other rules regarding the filing of motions. But there's the practical reality of when people are available. And so if people aren't physically able to be present, I don't see how we could potentially address anything any earlier. And I'll leave it at that. Is there an alternative proposal that you would like the court to consider regarding that issue?
Yes, Your Honor. There were 4 attorneys that signed or that listed their bar numbers on the answer.
And so I'm going to indicate I'm not going to make Lewis County have someone else respond at a hearing on that. Having been in that position before, it is clear that Lewis County wants Mr. Carter to represent them at these hearings, and I'm not going to put Lewis County in a position where they have to change horses, so to speak, for the resolution, at least of this matter as you've described it. In some circumstances, if something was truly exigent, I would consider that. In these circumstances, while I understand your client's desire to move forward in a speedy way with respect to any issue, I do not consider there to be sufficient exigent circumstances with that to seriously contemplate making Lewis County have a different attorney appear. So that should address that. Hopefully the parties can confer regarding a scheduling order for the briefing and the merits hearing, and I will sign one, hopefully that can be agreed.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.